The paper was 8.5 by 11 inches. Standard white. Standard weight. The kind of paper you'd use to print a grocery list or a school report. But this particular piece of paper had sat in a fireproof safe for 22 years. And when the attorney slid it across the mahogany desk toward me that Tuesday morning, my mother's face did something I had never seen it do before. It went completely still. I want you to understand something about my family before I tell you what was on that paper. We were not a loud family. We did not scream at dinner tables or throw dishes or say the cruel things out loud. My parents, Robert and Sylvia Harmon, operated on a different frequency entirely. Their cruelty was architectural. They built things. Structures. Arrangements. Situations that looked, from the outside, like perfectly reasonable decisions. And from the inside, felt like a room with no door. My name is Diana. I am 34 years old. I have a master's degree in financial analysis. I have spent the last 11 years looking at numbers for a living, finding the place where they stop adding up, the exact decimal point where something shifts from an honest mistake into something else entirely. I should have turned that skill on my own family years earlier. I didn't. That is the first thing I have to own. My grandmother's name was Eleanor Harmon. She was my father's mother. She passed away 9 years ago, in the November of the year I turned 25, in a hospital room that smelled of antiseptic and old flowers. I held her hand at the end. My father stood near the window. My mother did not come. Eleanor had been a quiet woman too, but her quiet was different from my parents' quiet. Hers came from strength. From having lived through things. She grew up without money, married a man who built a small business from nothing, and spent the second half of her life making sure that what they had built went somewhere meaningful. She talked about that often. Things should go to the right people, she used to say. She'd be at her kitchen table, hands wrapped around her coffee mug, looking at nothing in particular. Not just whoever's closest. The right people. I was 12 the first time I heard her say it. I didn't understand what she meant. Eleanor owned a property. That is the simple version. The full version is this: Eleanor owned a parcel of land, 14 acres, about 40 minutes outside the city, in a county that has since become extremely desirable. The kind of place where tech money moved in over the last decade, where farmland started selling for 8 and 10 times what it had been worth before. When I was young, that land was worth almost nothing. A small house on it. Some trees. A creek that flooded twice a year. When Eleanor died, she left a will. I was told, by my father, by my mother, by the family attorney at the time, a man named Gerald Fitch who has since retired, that Eleanor's estate had been settled. That the property had been sold some years prior. That there were debts. That after everything was handled, there was nothing substantial left. I was 25. I had just started my first real job. I had no reason to question it. So I didn't. I'm going to stop here and tell you something about grief. When you lose someone you love, truly love, in the particular way a grandchild loves a grandmother who actually saw her, your brain does a kind of triage. It decides what it can hold and what it sets down. I was devastated when Eleanor died. I was also young, newly employed, navigating a city alone for the first time, and completely dependent on my parents for the kind of basic family information that you don't think to verify. Like what was in a will. Like whether property was actually sold before someone died or after. Like what the words settled estate actually mean versus what someone can tell you they mean. I set that information down. I trusted my father. That is the second thing I have to own. The years after Eleanor's death were unremarkable in the way that slowly wrong things often are. My parents remained my parents. Present in the particular managed way they had always been present, birthdays acknowledged, holidays attended, phone calls made and received on a predictable schedule. My mother continued to manage conversations the way a conductor manages an orchestra, deciding what played, when, and at what volume. My father continued to exist in her orbit like a planet that had long since stopped generating its own light. We did not discuss Eleanor much. When I brought her up, a memory, something she'd said, a recipe I was trying to replicate. My mother would do this thing with her expression. A kind of gentle compression. Not dismissive exactly. More like, that chapter is closed. And my father would look at his hands. I noticed it. I filed it. I didn't know what to do with it. The thing that changed everything was a Tuesday afternoon in March, 3 years ago. Not a dramatic afternoon. A completely ordinary one. I was at my desk. I work in financial auditing, which means I spend most of my days inside other people's numbers, and my phone rang. The name on the screen was one I didn't recognize. Whitmore and Associates. I almost didn't answer. I'm glad I did. The voice on the other end belonged to a woman named Carol Whitmore. She was an estate and property attorney. She explained, carefully, methodically, in the particular tone of someone who has delivered complicated news to many people and has learned to slow down, that she had been engaged to handle a routine title search on a parcel of land in the county outside the city. That during the course of that search, her team had found a discrepancy. That the discrepancy involved a deed. That the deed involved my name. I remember the exact moment she said that. I set my pen down. I said, "Say that again, please." She said it again. According to the original deed of Eleanor Harmon's property, the 14 acres 40 minutes outside the city, there was a secondary clause. A handwritten addendum, notarized in 1994, 8 years before I was even in high school. Eleanor had added a provision to the deed. The provision stated that in the event the property was ever sold or transferred, a specific percentage of the net proceeds, 30%, was to be held in trust. For me. By name. Diana Claire Harmon. Named specifically. Not grandchildren. Not Robert Harmon's issue. Me. My full legal name in Eleanor's handwriting. Carol Whitmore had found it during a title search because the property, Eleanor's property, had recently been sold again. A developer had purchased it. The title search had surfaced the original deed, and with it, the addendum. Which had never been honored. Not 9 years ago, when Eleanor died. Not when the estate was supposedly settled. Not ever. I sat at my desk for a very long time after that call. I am not a person who cries easily. I process first. I feel later, if at all, and usually at inconvenient times, driving somewhere, or in the shower, or at 2 a.m. when there's nothing else to occupy my brain. So I did not cry. I opened a notepad, the paper kind, not a screen, and I started writing down what I knew. What I knew was this. Eleanor had left me something. Specifically. On purpose. In writing. Notarized. My parents had been the administrators of her estate. They had told me the estate had nothing. They had been wrong. Or they had lied. Those are the only two options in mathematics. A number is either correct or it isn't. There is no third category. I called Carol Whitmore back the next morning. I asked her 2 questions. First, was the addendum legally binding? She said yes. Unambiguously. Notarized provisions attached to recorded deeds are enforceable. The trust should have been established at the time of Eleanor's death and funded at the time of any property sale. Second, what was 30% of the sale price? She told me. I wrote the number down. I looked at it for a moment. Then I wrote it again, because writing it twice is how I make sure I've read something correctly. The number did not change. I want to be precise about what I felt in that moment. It wasn't rage. I've been asked that since, by people who've heard pieces of this story, weren't you furious? And the answer is that fury came later. What I felt in that first moment was something quieter and more specific. It felt like when you find the error in a spreadsheet that's been wrong for months. That small, precise, cold click of recognition. There it is. That's where it went. I did not call my parents. Not that day. Not that week. Not for 3 months. I spent those 3 months building a file. I am very good at building files. The file started with what Carol Whitmore had sent me. A scanned copy of the original deed. Eleanor's handwriting in the margin, careful, slightly slanted, the same handwriting that had signed birthday cards and grocery lists and the backs of photographs for my entire childhood. The notary stamp. The date, September 14, 1994. I was 6 years old in September of 1994. Eleanor had put my name in a legal document when I was 6 years old and never told me. Not because she forgot. I know that now. She didn't tell me because she knew something about my parents that I would spend the next 9 years learning the slow way. She knew they would find a way to take it. So she built a wall around it. And then she trusted that I would eventually be the kind of person who knew how to find walls. I requested the probate records from Eleanor's estate. This is a matter of public record. People don't know that. They think of wills and estate documents as private family business, and in the emotional sense they are, but legally, once a will goes through probate, it becomes a public document. Anyone can request it. Anyone can read it. I requested it under my own name. It took 11 days to arrive. I read it in one sitting at my kitchen table with a yellow legal pad and 3 different colored pens. Blue for facts, red for questions, green for things I needed to verify. I used a lot of red. The will itself was straightforward. Eleanor had left her personal belongings to my father. Her modest savings account, about $14,000 at the time of her death, split equally between my father and his brother, my Uncle Paul, who lives in Arizona and whom I have met exactly 4 times. The property was listed separately. And this is where the document became interesting in the way that only a person who reads documents for a living would find interesting. The will referenced the deed. Specifically. It said, and I am paraphrasing only slightly, the disposition of the real property located at, address, shall be governed by the terms of the recorded deed and any addenda thereto. Addenda thereto. Those 2 words. The will itself pointed directly to the addendum. Gerald Fitch, the attorney who handled the estate, would have read those words. Would have been obligated to pull the deed. Would have seen Eleanor's handwriting in the margin. I wrote Gerald Fitch on my red list. The property had been sold twice, and I drew a circle around it. This I learned from the county recorder's office, which maintains a database of property transfers that is, again, entirely public record. The first sale, 14 months after Eleanor's death. My father listed as the seller. A family named Kowalski as the buyer. Sale price, $240,000. I did the math. 30% of $240,000 is $72,000. That was the trust that should have been established for me. That was the amount my parents had received, handled, and never mentioned. The second sale, 18 months ago. The Kowalski family selling to a development company called Meridian Group. That was the sale that had triggered Carol Whitmore's title search. That was the sale that had surfaced Eleanor's addendum. The Kowalski family had nothing to do with what happened. They bought the property in good faith and sold it legally. They were not part of this. The problem was what happened between Eleanor's death and that first sale. The problem had a name. Several names, actually. I called my Uncle Paul in Arizona on a Wednesday evening. I had not spoken to Paul in approximately 3 years. We are not close, not because of any conflict, but because distance and different lives create their own kind of silence. He is a quiet man. Retired. He used to build custom furniture. He has a dog named Chester and a wife named Margaret, and he sounds like my grandmother more than anyone else I know. I told him I was doing some research into Eleanor's estate and had some questions. He said, finally. I said, excuse me? He was quiet for a moment. Then he said, I always thought there was something off about how Robert handled that property. I asked Gerald Fitch about it at the time. He told me everything had been properly discharged. I didn't know enough to push back. I asked him what specifically had felt off. He said, your grandmother told me once, must have been a year or 2 before she got sick, that she'd made arrangements for you. That she wanted to make sure you had something independent. Something that was yours and not anyone else's business. He paused. When Robert told me the estate was clean, I thought maybe she'd changed her mind. Or I told myself that. He was quiet again. Then, she wouldn't have changed her mind. I wrote that down in blue. That was the first twist. Not a dramatic one. No confrontation. No shouting. Just a quiet phone call to a man in Arizona who said finally when I told him I was looking into it, and who confirmed in the plainest possible terms that Eleanor had told people what she intended. She had not kept it secret from everyone. She had kept it secret specifically from my parents. And my parents had proceeded as though the secret didn't exist. That distinction matters enormously. I want to tell you about my mother for a moment. Sylvia Harmon is a woman of considerable competence and very specific appetites. She is organized in the way that control-oriented people are organized, not because order brings her peace, but because order gives her advantage. She knows where everything is. She knows what everything costs. She knows what people owe her, and she keeps that accounting internally, in a ledger that never closes and never forgives an entry. She is also, genuinely, charming. This is important to understand. The people who knew my parents socially, neighbors, their church, my father's colleagues, they liked Sylvia. She remembered names. She sent cards. She brought food when people were sick. She laughed at the right moments and asked the right questions. She was also the person who stood in my grandmother's kitchen 6 weeks before Eleanor died and said, within my earshot, I was 24, I was right there, I hope Eleanor has been sensible about the property. Robert has worked very hard and it would be nice if things were straightforward. She said it to no one in particular. She said it so that I would hear it. I remember thinking, that's an odd thing to say. I filed it. I kept filing things. The file just never had a home until Carol Whitmore called. By the end of month 2, my file contained the following. The original deed with Eleanor's addendum. The probate records. The 2 property transfer records. My notes from the call with Paul. A printed copy of the relevant section of the state probate code, which outlines an executor's fiduciary obligations. A list of questions for a legal consultation. And one more thing. A birthday card. Eleanor sent me a birthday card every year without exception, from the time I was born until the year she got too sick to manage it herself. I had kept them all in a shoebox. Most of them were exactly what you'd expect, cheerful illustrations, a few warm sentences, her signature. But the one from my 23rd birthday, 2 years before she died, had a line at the bottom I had read and not understood at the time. She wrote, I want you to know that I've thought carefully about what's fair and I've done what I could do. You'll find it when the time is right. I trust you to look. I had thought she was talking about something spiritual. Something about life, or choices, or finding your path. She was not talking about any of those things. She was talking about a deed. She was leaving me a trail. Month 3. I scheduled a consultation with an estate litigation attorney named Patricia Osei. I chose her specifically. She had a record of probate fraud cases, actual published case outcomes, which you can look up, which I did. She was not the most expensive attorney I could have found. She was the most precise. I brought her the file. She read it for 45 minutes while I sat across from her and drank terrible waiting room coffee. Then she looked up. She said, Did you know that probate fraud has a civil statute of limitations that runs from the point of discovery, not from the original event? I said I had read that. She said, So you understand what that means? I said, It means the clock started when Carol Whitmore called me. Not when my grandmother died. She looked at me for a moment. She said, I think we have a case. She asked me one more question before we wrapped up that first meeting. She said, Have you spoken to your parents about any of this? I said no. She said, Good. Don't. I said, I wasn't planning to. She almost smiled. She said, I can tell. There is something I need to be honest with you about. In the middle of month 2, somewhere between pulling the probate records and calling Paul, I had an evening where the analytical machinery shut down and the other thing came in. I was sitting at my kitchen table with Eleanor's birthday cards spread out in front of me. All of them. 40+ years of them, from my parents' collection before I was born, the ones addressed to my father that Eleanor had sent when he was young, that my mother had kept in a box in the hall closet and that I had taken years ago when I thought I was taking them for sentimental reasons. I was looking at Eleanor's handwriting. The way it stayed consistent through the decades. A little more careful when she got older. The same slight leftward slant. And I thought, she knew. She knew what they were like. She had watched her own son for decades. She had lived with the particular helplessness of loving someone who has chosen the wrong person, and watching that choice slowly rearrange them. She could not fix it. She could not change my father. She could not make my mother into someone different. What she could do was put my name in a deed. What she could do was trust that I would find it. She had done everything she could do. And then she died, and my parents had erased it, and for 9 years I had not found it because I had not looked. I put my head down on the kitchen table. I stayed there for a while. Then I picked up the blue pen. And I kept going. Patricia Osei filed the initial claim on a Thursday in June. I know the exact date because I was sitting in my car in the parking garage beneath her office building when she texted me the confirmation. I had not been able to make myself go home. I had driven to the garage, parked, and just sat there with the engine off for 20 minutes, which is the kind of thing I do when my brain needs to process something it cannot fully process yet. The text said, filed. Defendants have 30 days to respond. I'll be in touch. Defendants. My parents were defendants. I sat with that word for a long time in that parking garage. The claim was civil. Not criminal, though Patricia had explained there was a theoretical criminal dimension involving the executor's conduct. We were pursuing the civil route first because it was faster, more controllable, and because the standard of proof is lower. You do not need to prove intent beyond a reasonable doubt in a civil case. You need to prove that the fiduciary obligation existed, that it was breached, and that harm resulted. The fiduciary obligation, established by the probate records. The breach, established by the property transfer records showing no trust was ever created. The harm, established by the math. $72,000. Plus 9 years of what that money would have grown into if it had been properly invested in a trust. Patricia's financial expert put the figure, with interest, conservative investment assumptions, and applicable penalties, at just over $114,000. I wrote that number down. I wrote it twice. My parents received the filing 26 days after Patricia submitted it. I know this because my mother called me on day 27. I was at my desk at work. It was a Tuesday morning, which felt appropriate given that this entire thing had started on a Tuesday morning in Carol Whitmore's office. My phone lit up with my mother's name and I looked at it for 3 rings before I answered. I said, hello. She said, Diana. Just my name. The way she said it told me everything. Not angry, not yet. Calibrating. She was taking the temperature of the room the way she always took the temperature of every room before she decided what to do in it. She said, we received some paperwork. I said, I know. Silence. She said, I think there's been some kind of misunderstanding. I said, I don't think there has. Another silence. Longer this time. Then she said, in the particular tone she used when she was repackaging something ugly into something presentable, Diana, your grandmother's estate was complicated. There were debts that weren't immediately apparent. Gerald handled everything according to what was appropriate at the time. If there was an oversight. I said, it wasn't an oversight. She stopped. I said, I've read the probate code. I've read the deed. I've read Gerald Fitch's filing. The addendum was recorded. It was referenced in the will. The obligation was clear. She was quiet for a moment. Then her voice changed. Not dramatically. Just a small tightening, like a screw being turned 1/4 turn. She said, I hope you understand what you're doing to this family. I said, I do. And I hung up. I want to be clear about something. That phone call was not satisfying in the way people imagine it would be satisfying. It was not a moment of triumph. My hands were shaking when I put the phone down. I sat very still at my desk for a full minute and stared at the spreadsheet on my screen without seeing a single number in it. Because no matter what my parents had done, and what they had done was specific and documentable and wrong, there is a particular grief in the moment you stop pretending. Pretending that the explanation might be innocent. Pretending that oversight is possible when the will itself points to the clause. Pretending that the family you have is the family you thought you had. I had been pretending for 9 years. The pretending was over now. That is not a clean feeling. It just is what it is. My father called 2 days later. I answered on the first ring because I wanted to hear what he would say. His voice was quieter than my mother's. Slower. He sounded, if I'm being precise, like a man who had not been sleeping well and was calling because he had been told to call, not because he had chosen to. He said, Diana. I want to explain some things. I said, okay. He said, when your grandmother passed, there was a lot happening. The estate was more complicated than anyone anticipated. Gerald advised us that the addendum had no practical effect because, he paused. Because the debts against the estate exceeded. I said, Dad. He stopped. I said, the property sold for $240,000. Eleanor had a $14,000 savings account and no mortgage on the property. I've pulled the full probate records. There were no debts that would have absorbed the net proceeds. Silence. A long one. He said, Gerald said. I said, Gerald Fitch filed the estate paperwork. It's public record. The debts listed are itemized. I've added them up. They totaled $31,000. The net proceeds from the property sale after those debts were cleared were just over $200,000. 30% of that is $60,000. That is what should have gone into a trust for me. More silence. Then, very quietly, Diana. I said, I'm not angry at you, Dad. That surprised him. I could hear it. I said, I'm just done pretending the numbers say something different from what they say. He didn't speak for a moment. Then he said, your mother. And he stopped himself. Those 2 words. Your mother. He said them and then he stopped himself and I understood everything that had just not been said, and I think he understood that I understood, and we stayed on the phone together in that shared understanding for another few seconds before he said he had to go. He hung up. I stared at the wall. The next 6 weeks were the worst of the process. Not because of what was happening legally. Patricia was methodical and steady and the case was proceeding exactly as she had said it would. But because of what was happening personally, which is a thing that legal proceedings do not prepare you for and which no one warns you about adequately. My parents told people. Not the truth. They told people a version. I became, in the story they were circulating through their social world, a daughter who had been manipulated by a predatory attorney into suing her own grieving parents over a clerical error in her late grandmother's estate paperwork. A daughter who had always been difficult. A daughter who had chosen money over family. I know this because my aunt, my mother's sister, a woman named Carol who lives 20 minutes from my parents and who had always been kind to me in the uncomplicated way of people who exist at the edges of family conflict, called me and said, very gently and with obvious discomfort, Diana, I've been hearing some things and I just wanted you to know I wanted to ask you directly. I told her directly. She went very quiet. Then she said, oh. Just that. Oh. I lost 2 cousins during those 6 weeks. Not permanently, as it turned out, but at the time it felt permanent. My mother's side of the family operated on information she provided, and the information she provided was specific and consistent and designed to position me as the aggressor. 2 of my cousins, women I had grown up with, spent holidays with, been genuinely close to in the easy way of childhood before adult lives pull people in different directions, stopped responding to my messages. One of them sent me a single text, I really hope you know what you're doing. I read it several times. I wrote back, I do. She didn't respond. The cry moment came on a Sunday night in late August. It was not connected to a dramatic event. There was no phone call, no piece of news, no catalyst that a storyteller would choose for maximum effect. I was washing dishes after dinner, alone, in my apartment, which I have lived in alone for 4 years, and a song came on that Eleanor used to hum in her kitchen. One of those old songs. The kind that doesn't have a streaming profile or a cultural moment, just a melody that belongs to a specific person in a specific place and sounds like nothing else in the world. I stood at the sink. And I thought, she would have hated this. Not what I was doing. She would have understood what I was doing, she had built the mechanism that made it possible. But she would have hated that it was necessary. She would have hated that her son was the reason. She would have sat at her kitchen table with her hands around her coffee mug and looked at nothing in particular and felt the particular sadness of someone who did everything they could do and watched the thing they feared happen anyway. I stood at the sink and I cried for about 10 minutes. For Eleanor. For the version of my father that existed before my mother finished reorganizing him. For the cousins who had stopped texting. For the 25-year-old version of me who stood in a lawyer's office and was told there was nothing and nodded and went home and believed it. 10 minutes. Then I dried my hands. Then I went back to the table where my file was open and I looked at the numbers for another hour. Patricia called me the following Tuesday. She said, they've responded to the filing. I said, and? She said, they're contesting it. Their attorney is arguing that Gerald Fitch's interpretation of the addendum at the time of the estate settlement was a reasonable professional judgment, and that any claim is therefore barred by, Diana, are you following me? I said, they're arguing that their attorney made a judgment call and that judgment call was reasonable and therefore the clock ran from Eleanor's death, not from my discovery. She said, correct. I said, is that argument going to work? She paused. She said, it's not a frivolous argument. We'll need to counter it. I want to depose Gerald Fitch. I said, okay. She said, this could get complicated. I said, it already is complicated. She said, more complicated. I said, schedule the deposition. She did. Gerald Fitch was 71 years old. Retired. He had been practicing estate law for 34 years before he stopped. He was, by all accounts, a careful professional who had handled hundreds of estates without incident. He agreed to the deposition voluntarily. That surprised Patricia. It surprised me too. I found out why at the deposition itself, which I attended and watched from a chair in the corner of Patricia's conference room, where I sat with my legal pad and my 3 pens and said nothing and wrote everything. 30 minutes into the deposition, Patricia asked Gerald Fitch whether he had reviewed the recorded deed, including any addenda, prior to filing the estate paperwork. Gerald Fitch looked at his hands. Then he looked up. He said, I reviewed the deed. Patricia said, and were you aware of the handwritten addendum naming Diana Harmon as a beneficiary of 30% of proceeds from any property sale? He said, I was. Patricia said, and did you advise the executor, Robert Harmon, of this provision? Gerald Fitch was quiet for a long moment. Then he said, I did. The room went completely still. Gerald Fitch kept talking. Once he started, he did not stop for a long time. Patricia had the presence of mind to simply let him go. She put her pen down on the legal pad in front of her and she let the man talk, which is a skill that I have come to understand is rarer and more valuable than it looks. Gerald Fitch said that he had advised Robert Harmon of the addendum on the day he reviewed the deed, approximately 3 weeks after Eleanor's death, during the initial estate inventory meeting. He said my father had read the provision. Had read Eleanor's handwriting. Had sat quietly for a moment and then asked Gerald what the practical implications were. Gerald had explained them. My father had nodded. Then my father had said, and Gerald quoted this directly, in the flat careful voice of a man who had been holding something for 9 years and had finally found the place to put it down, my father had said, we'll need to discuss this as a family before we decide how to proceed. Gerald said he had understood that to mean Robert would consult with his wife and return with a decision about how to handle the trust provision. Robert never returned with a decision. What happened instead was that 3 weeks later, my father called Gerald and told him that the family had reviewed the provision and that they believed, given the estate's debt obligations, that the addendum was effectively nullified. That the net proceeds would not be sufficient to fund a meaningful trust after debts were satisfied. Gerald said he had pushed back. Gerald said he had told my father, in clear terms, that the debt calculation my father was presenting did not align with Gerald's own assessment of the estate's obligations, and that he could not in good conscience file paperwork that disregarded a notarized deed provision. And then Gerald Fitch said the thing that I wrote down 4 times. He said, Mr. Harmon told me that his wife had spoken to a colleague of mine. That if I filed paperwork that created complications for the family, there would be a complaint filed with the Bar Association regarding my handling of a previous estate matter. Patricia said, he threatened you. Gerald said, Mrs. Harmon did. Through Mr. Harmon. Patricia said, and you complied. Gerald looked at his hands again. He said, I told myself the debt argument was defensible. That a reasonable person could interpret it differently. He paused. I have thought about that a great deal in the years since. The room was very quiet. I looked at my legal pad. I had written the number 4 times. I looked at the window instead. I want to tell you what I felt in that moment, and I want to be as precise about it as I have been about everything else. It was not triumph. It was not satisfaction, at least not immediately. What I felt first was something closer to the sensation of a very long equation finally resolving, the kind where you have been carrying an unknown variable for years and suddenly the variable has a value and everything on both sides of the equation balances, and there is a specific cognitive relief to that which has almost nothing to do with emotion. The variable was, did my father know? The answer was, yes. The secondary variable was my mother the architect? The answer was, yes. Both sides balanced. The equation was complete. Patricia moved quickly after the deposition. Gerald Fitch signed a sworn affidavit the following week. His testimony was now on record, the addendum had been known, disclosed to the executor, and deliberately disregarded under duress. This shifted the legal landscape considerably. The argument my parents' attorney had been making, that Gerald's handling represented a reasonable professional judgment, collapsed entirely once Gerald himself testified that his handling had not been professional judgment. It had been coercion. Patricia filed an amended claim. We added a cause of action for intentional breach of fiduciary duty. We also filed a separate complaint with the State Bar regarding Gerald Fitch's conduct, not to destroy him, but because Patricia advised that it was legally necessary for the integrity of the case, and because it was true. He had complied with something he shouldn't have complied with. He had admitted it under oath. The bar would decide what to do with that. That was not my decision to carry. My parents' attorney made one more attempt. He reached out to Patricia 4 weeks after the amended filing and proposed a settlement discussion. I sat in Patricia's office on a Thursday afternoon and listened to the terms their side was proposing. They were willing to pay $60,000. The original 30%. No interest. No penalties. No acknowledgement of intentional conduct. And a confidentiality agreement. Patricia looked at me across her desk. I looked at the number they had written on the proposal sheet. $60,000. The amount that should have been set aside 9 years ago. The amount that had existed in Eleanor's handwriting on a deed in 1994. I thought about the Sunday night at the sink. The 10 minutes. Eleanor humming in her kitchen. My father saying your mother and stopping himself. I thought about my cousins who had stopped texting. I thought about a 25-year-old who had stood in a lawyer's office and believed what she was told because she trusted her father. I said, no. Patricia said, the confidentiality clause specifically. I said, I know what the confidentiality clause means. No. She nodded once. She picked up her pen. The case went to mediation in October. Mediation is a strange process. You sit in separate rooms and a neutral third party moves between them, carrying offers and counteroffers like a translator working in a language neither side fully speaks. You do not see the other party. You do not have to. I sat in Patricia's assigned room for 4 hours. I drank more terrible coffee. I read a book on my phone that I do not remember anything about. Patricia came and went. The offers moved. At the end of the 4th hour, Patricia came in and sat down across from me and put a single sheet of paper on the table between us. She said, "This is their final offer." I looked at the number. $109,000. Full acknowledgement in the settlement agreement that the trust provision had not been honored. No confidentiality clause. I looked at it for a moment. I said, "What's your read?" She said, "Honestly, we might do slightly better at trial. We might also do slightly worse. Juries are unpredictable with family cases. But this number is within 5% of our projected recovery, it's in writing, and it contains the acknowledgement." I said, "The acknowledgement matters." She said, "I know it does." I picked up the pen. I signed. The check arrived on a Wednesday. I deposited it and then I sat in my car in the bank parking lot for a while, which seems to be a thing I do now at significant moments. $109,000. Eleanor's 14 acres outside the city, filtered through 9 years of litigation risk and human dishonesty and one retired attorney's guilty conscience, arriving finally in the form of a direct deposit notification on my phone. I thought about what Eleanor would say. I think she would say, "Good." Not in a triumphant way. In the way she said things, simple, direct, without drama. She had done what she could do. I had done what I could do. The thing she intended had arrived where she intended it to go. Good. There are things I need to tell you about what came after. My mother sent me an email 3 days after the settlement finalized. It was 4 paragraphs long. I read it once. It used the word disappointing 3 times and the phrase what Eleanor would have wanted twice, and it contained no apology of any kind and no acknowledgement of anything in the settlement agreement. I did not respond. My father called once. He did not leave a voicemail. I did not call back. My cousin, the one who had texted "I really hope you know what you're doing," reached out 6 weeks after the settlement. She had heard, through my Aunt Carol, what the actual facts were. She said she was sorry for going quiet. She said she felt embarrassed. I told her she didn't need to feel embarrassed. I told her my mother is very good at information management. She laughed a little, the way people laugh at things that are painful and true. We have had dinner twice since then. That is something. I want to tell you about what I did with part of the money. I kept most of it. It went into investments, careful, diversified, the kind Eleanor would have approved of. The kind that grow slowly and don't make anyone rich overnight but build something real over time. But I took $12,000 of it and I did something specific. Eleanor had a favorite charity. A small local organization that ran after-school programs for kids in the county where she had lived, the same county where her 14 acres had sat for decades. She had volunteered there when she was well enough. She had talked about it. I made a donation in her name. I asked them to send an acknowledgement letter to my father's address. I want to be honest, that last part was not purely generous. There was some calculation in it. There was the specific satisfaction of making sure that something arrived at that address with Eleanor's name on it, in the context of giving rather than taking. I'm human. I own it. The last thing I want to tell you is this. A few months after everything was settled, I was going through the birthday cards again. Not for evidence this time. Just because I wanted to. I got to the one from my 23rd birthday. I want you to know that I've thought carefully about what's fair and I've done what I could do. You'll find it when the time is right. I trust you to look. I read it several times. Then I turned the card over. I don't know why I turned it over. I had read that card many times. I thought I knew everything on it. On the back, in Eleanor's slightly slanted handwriting, was one more line. I had never noticed it before. It was small. Written close to the edge, the way you write something you almost didn't write, something you added at the last moment before sealing the envelope. It said, "You were always the one who paid attention." I held the card for a long time. Then I put it carefully back in the shoebox. I closed the lid. And I finally let it be over. There is something Eleanor understood that took me 34 years to fully learn. Quiet people are not powerless people. She could not stop what she knew was coming. She could not change my father or outmaneuver my mother directly. She was one woman with 14 acres and a notary stamp and a grandchild she believed in. So she built the most careful thing she could build. She put my name in a document. She trusted me to pay attention. I almost didn't. I almost went my whole life without looking. And some days I still think about that, how close the whole thing came to disappearing completely into the silence my parents were so expert at maintaining. But Eleanor knew something about me before I knew it about myself. She knew I would look. She was right. What is the one thing someone did for you, quietly, without announcement, that you only understood years later? Leave it in the comments. I'll be reading. Subscribe if you're staying. New story every day.